I think to understand this, you really do have to start with 9/11. I mean, it's easy to forget now, but not many Canadians perhaps realize that part of the Patriot Act, which was passed with kind of blinding speed after 9/11, is called Protecting the Northern Border. So it's not just Bill O'Reilly and then Janet Neapolitan who seem to have bought into this idea that the 9/11 attackers came from Canada. It's actually really quite entrenched in U.S. law and the Patriot Act. And of course, a lot of this had to do with the Rassam case, who was apprehended by an alert American border guard with plans and was subsequently convicted of wanting to bomb LAX at the Millennium. But really this for me, started a dynamic where Canada, and perhaps historically, as Stephen has suggested, we've been willing to do this, but Canada went out of its way to cooperate with the United States in the wake of the huge trauma of 9/11, but also a lot of suspicion about the northern border. And as Audrey has mentioned, I mean, the Mayor Arar and the related cases, for me, are really quite central for understanding this agreement. So this agreement talks about, on page 4, promoting increased informal sharing of law enforcement intelligence, information, and evidence consistent with respective domestic laws of each country. Well, this idea of sharing information / intelligence / evidence is, really part of a phenomenon, global phenomenon since 9/11, where intelligence, which is really educated guess about security threats, is used as evidence to impose legal consequences such as being on a no-fly list and more. And so, the Arar case was, and it wasn't the only example, was an example where the RCMP basically burned 3 CDs of active files that focused on El Mati, but mentioned Mayor Arar as a person of interest. And so, we don't know, because the Americans declined an invitation to participate in the Arar Commission, but I think it's highly likely that information, which was not screened for privacy, was not screened for relevance, no caveats or restrictions were placed on the use of that information by the Americans. It's highly likely that information was used as part of a summary immigration process that saw Mr. Arar detained in New York City and then removed to Syria, where he was tortured and held for almost a year. And so, the fact that the Arar and similar cases are invisible in this agreement, I find, is deeply troubling for a number of reasons. On the American side, I don't know how many of you are aware of this, but Mayor Arar is still on a U.S. watch list. The fact that we spent millions of dollars and had Justice O'Connor look at everything and said he found no evidence that Mr. Arar was a threat to national security has not persuaded the Americans under either the Bush or the Obama administrations. And we don't know, right? I mean, they showed the information to Stockwell Day, and Stockwell Day was not convinced that Mr. Arar was a security threat. I mean, this to me is a very significant issue that Mr. Arar can still not go to the United States. And when he testified before a congressional hearing, many people who genuinely, on both sides of the aisle, apologized for his mistreatment. He was still doing it by video link from a location in Ottawa. I was also testifying, but that was because the U.S. Congress was too cheap to pay for people to go down to Washington to testify. But the American watch list that Audrey mentioned are huge compared to, say, our Passenger Protect, and have much less checks and balances built into it. So that's the American side. On the Canadian side, and as Audrey mentioned, that although the Canadian government, although the Harper government agreed with the initial report that Justice O'Connor handed down, they ignored a second report that I increasingly think was a strategical mistake not to release it at the same time, that basically said that our review structures with respect to information sharing were hopelessly antiquated. I mean, basically, around the world, post 9/11, it's all been about going outside silos, knocking down walls. We still have a very, very traditional accountability structure where the Security Intelligence Review Committee, which reviews CSIS, has no jurisdiction when the information goes from CSIS to the RCMP, to DFATE, to Customs. We also, because we have no federal ombudsman, military intelligence, CBSA, FinTrack, all of these agencies are subject to no independent review, right? Are they theoretically subjected to parliamentary review? Well, I guess. But our parliamentarians can't even see secret information unless a retired judge holds their hand and says that it's okay. So basically, the Arar Commission made some fairly sweeping recommendations that, it was not opposed to information sharing, but said as a general principle, as national security activities increase, so does independent review and checks. And the Harper government ignored this until 2010, when they introduced a bill which was never passed that somewhat expands the RCMP complaints body's review function, but does not, as Justice O'Connor recommended, give them access to secret information, right? The issue on secret information is you can't do review, because everything's secret. You can't do review unless you see the secret information. You have the fight about what you can make public, and that was a fight that the Arar Commission and other people have, and as Audrey has suggested, should be resolved according to the rule of law in court. So, I think that before Canada would agree to increased informal information sharing, which is of the essence of the Arar affair, we would have gotten our own accountability house in order. Now you might say, well, that was then, right? The Americans are not going to take someone off a plane and send them to Syria, and I hope that that's right. And the Monterey Protocols at least, contemplate some consultation, but certainly not a veto. So it's still possible under the Monterey Protocols for a Canadian of dual nationality to be removed from the United States to another, not to Canada. And of course, the reluctance to allow Arar to return to Canada was part of this kind of American skepticism about our ability to do counterterrorism. But we've recently had WikiLeaks disclosures which suggest that we're still sending the names of people to the United States, including the names of the Toronto 18, but perhaps a little more disturbing, the name of Mubin Sheikh, the telegenic informer in the Toronto case. His name was on that WikiLeaks that we sent to the US to be included on their Viper list. So, I do have some real concerns. Now, as Audrey mentioned, the plan does, I think, put the cart before the horse in committing us to more informal information sharing, and then saying, well, in May 2012, and of course they've already missed one deadline, there will be joint privacy principles are articulated between Canada and the U.S. And Audrey talked about law, and I agree that, you know, intelligence sharing is something that is generally not subject to the rule of law. I predict that in those principles you will see a lot of reference to, you know, this is in compliance with Canada's Privacy Act. And you might say, well, that's great, right? I mean, Privacy Act, I mean, what could be wrong with that? Well, the problem is our Privacy Act has lots of exceptions for consistent use, national security exceptions, and the Aurora Commission looked at the restraints that the Privacy Act placed. And they're really not particularly adequate, and they're not self-enforcing. I mean, the problem with information sharing is that none of us in this room knows whether information about us is being shared if that information is subject to secrecy claims. So just to kind of finish up, so I mean the commitment to informal information sharing, my position is not that we should not share information with the U.S. I think that we should, but we need to at least have our review house in order. And of course, the last thing is, if information that is shared is misused, what about remedies? And here, of course, we do have two very different legal traditions, and you know, the Canadian government settled with Mr. Arar. They're fighting the other cases where the same information was used by the U.S. and Syria and resulted in complicity in torture. But those cases are being litigated, where the Americans, their state secrets doctrine is really quite extraordinary. And so if you think about Guantanamo or extraordinary rendition or warrantless spying or targeted killing, all of these are basically not reviewable under U.S. law. So, I mean, you know, John talked about some continued differences, and I think that we still have at least the possibility of some accountability, not in any way discounting how difficult that will be. But we also have to recognize that if Canadians are harmed, as they have been by information sharing, it's very unlikely that they will be able to obtain any remedies south of the border. Thank you very much.